Virginia's background check law is no more. The final order in Wilson v. Hanley was just issued by the court. Let's talk about it. The case of Wilson versus Hanley has been going on since 2020. There have been years of litigation going on. Of course, as you know by now, if you've been watching this channel, there has been a lot that has happened with the Second Amendment since 2020. Notably, the Bruen case has come out. And then even further after that, there was the Rahimi case. So all of this has happened since Wilson versus Hanley started. And the court took note of this. On October 16th, 2025, the 24th Judicial Circuit of Virginia issued an opinion letter. So this is a little bit different than an order. An opinion letter is a letter from the judge to both the plaintiff and the defense to let them know what they are inclined to rule. So on June 4th, 2025, the parties had oral arguments about this case, and the court came to a decision. So its opinion letter was the court letting the parties know how it's going to rule, but asking the parties to provide proposed orders for the court to rule on. So this is what the judge did on October 16th. In this opinion letter, the judge recognized that Bruen and Rahimi have come out since this case's inception. However, this is not actually what the judge based its ruling on. The judge based their opinion on the fact that the law was unconstitutional as applied to certain groups. So the question the court was considering in this case is whether Virginia Code Section 18.2-30825 is constitutional. This is the law that mandates background checks for firearm sales in Virginia. And this even includes private sales. So this was a really big deal affecting many Virginians. Let's dive into what the law actually says. It reads, "No person shall sell a firearm for money, goods, services, or anything else of value unless he has obtained verification from a licensed dealer in firearms that information on the prospective purchaser has been submitted for a criminal history record information check as set out in another statute, and that a determination has been received from the Department of State Police that the prospective purchaser is not prohibited under state or federal law from possessing a firearm, or such sale is specifically exempted by state or federal law. The Department of State Police shall provide a means by which sellers may obtain from designated licensed dealers the approval or denial of firearm transfer requests based on criminal history record information checks." So again, all of that to say, every firearm sale in Virginia required a background check under this law. Now, this had major impacts. So what the court found here was that the impact of this law really targeted 18 to 20-year-olds in an unconstitutional manner. The reason is, under this law, 18 to 20-year-olds are effectively banned from purchasing handguns. The reason why is when a background check is run on an 18 to 20-year-old, it is automatically denied by the National Background Check System. And this is the common system that pretty much all firearms sellers use in the country. There are some other options for using background checks, but this is what most people rely on. So here the court found that when you're applying this law to 18 to 20-year-olds, it is unconstitutional. And the court found this pretty early on in the litigation process. The court actually issued an order enjoining law enforcement from enforcing the act as applied to 18 to 20-year-olds while this case was going on. Now, the state tried to do some things to remedy the law and try to get creative, but at the end of the day, both parties really wanted the court to find whether requiring background checks for private sales of handguns is constitutional or not. However, the Virginia court really did not want to answer this question. Even though this is what both parties wanted an answer to, they agreed on this. The court said, no, no, no. We have to deal with what I think are the problems in this statute. And again, the court was laser focused on the fact that there were infirmities in the statute because it targeted 18 to 20-year-olds. And the court redirected both parties to redo their argument based on what the court found was important. The court pointed out here that there is actually a legal precedent that parties can follow when a court finds that a statute is unconstitutional as applied to a certain group. This case is the Ayotte case. It is a three-prong test. So the court wanted both sides to present how this should work under the Ayotte three-prong test. Let's go over those prongs together. The first prong is that the court must refrain from nullifying more of the law than necessary. This means that if there's an unconstitutional part of the law, that the court doesn't necessarily have to throw out the entire law. they can throw out only the part that is unconstitutional. So if there's a way to still preserve the law and remove the offending part, that is what the court is supposed to do. However, under prong number 1, the court ultimately found that there was no way to effectively sever this law. For example, if they severed the part affecting 18 to 20-year-olds, this would mean that 18 to 20-year-olds would not need a background check, but anyone older than 21 would need a background check. This doesn't really make sense, right? This isn't the spirit of the legislative intent. The legislative intent of this law was that everyone should have background checks. Whether background checks are reasonable or not is another story. The legislative intent was not to remove 18 to 20-year-olds' rights to purchase handguns, however. So here, severing the law doesn't really make sense. It's not logical to require anyone 21 years and up to get a background check, but just because someone's younger, they don't have to, because then the law would be unconstitutional as applied to them. The court noted this was not logical, so severing the law here was not really possible. The second prong is that the court should not rewrite the law unless it's a susceptible law to do so. So the standard is courts are not supposed to rewrite the law because, of course, we have separation of powers in this country. The judiciary is supposed to assess laws to see if they're constitutional or not, but it's really the legislative body's job to write laws. So here, the judiciary is only supposed to rewrite the law if it's really like a minor tweak. But the court found here that that was not the case. The court found that if they were to rewrite the law here, that they would be exceeding their judicial authority. So again, the test kind of fails under prong 2 as well. The third prong is whatever remedy the court decides must be in line with legislative intent. The reason why is courts are not supposed to use their power to circumvent legislative intent. Here, the court examined legislative intent and decided that the state was not trying to create arbitrary age-based restrictions. This would be unconstitutional in itself and create all kinds of issues with the Equal Protection Clause. So the court knew that legislative intent was not to create some separation between 18 to 20-year-olds and 21-year-olds and older. So here, again, after analyzing this 3-prong test, the court found that the law was unconstitutional as applied, and the only remedy would be to get rid of this act altogether. The court wanted to make it very clear that they are not holding that background checks are unconstitutional for private sales. It's possible it's unconstitutional. They are just not reaching that question in this decision. So it's very possible that Virginia could make a new law to replace this law that was now found unconstitutional, and we could have a whole new legal battle in the future to determine this question. However, at this time, that ultimate question that both parties were so curious about is going to go unanswered. In its letter, the court directed the plaintiff to write an order for the court to sign off on in accordance with its ruling. The plaintiff did just that and provided an order. The defense did not agree with the order here, but the court decided to sign the order with some minor modifications. In its order, the court found that the law is unconstitutional as applied to adults 18 to 20. So the court struck down the act in its entirety. Next, the court found that Virginia law enforcement is enjoined from enforcing the act in the future. Third, the court found that all previous temporary injunctive relief is now dissolved, and this order is now the permanent relief in this case. The court ordered a few other things. They're just small procedural matters. Overall, this was a big win for the Second Amendment community. Many people were outraged about this act, and we're glad that it was struck down in Virginia. However, like I said earlier, I think the fact that this was struck down as an as-applied challenge is a big deal. This means that Virginia is able to create future laws in this area and can really target people regarding background checks, including background checks on private sales. I assume if this happens, there will be future challenges against those laws. But it just means that we're probably going to have a whole lot of litigation ahead of us. So it's something to look out for in the future. It's going to be very interesting to see what the Virginia legislature does next. So what do you think? Do you agree with the court's ruling? Or do you wish the court had reached the ultimate question that we all want to know the answer to? Are background checks for private sales unconstitutional? Let us know what you think in the comments. Thank you again for watching this video. If you want to learn a little bit more about our law firm, head over to attorneysforfreedom.com. The Attorneys for Freedom Law Firm is the only law firm in the country exclusively committed to self-defense cases. You should also head over to attorneysonretainer.us. Attorneys on Retainer is our self-defense protection program. In our program, we have 3 simple criteria for coverage. The first criteria is that you are charged with a crime or reasonably expect to be charged with a crime. The second criteria is that you can assert self-defense or defense of others as a defense to that crime. And the third criteria is that the charges arose fully after becoming an Attorneys on Retainer member. So again, if you want to learn a little bit more, head on over to attorneysonretainer.us. And we have big news. Attorneys on Retainer just added the new 4 attorneys benefit. That means if you go to trial on a felony case with AOR, you will be guaranteed to have 4 attorneys sitting in the courtroom with you. And while you're here, be sure to like, comment, share, and subscribe. Thank you again for watching this video. Until next time, peace.